This is a Southern Sin breaking news special. Be sure to like and subscribe now.
Subscribe to at Southern Sin and hit the bell for when we go live. Thank you for watching at Southern Sin, your home for true crime. Smash the like button now.
Just a database of the people's lives.
I'll identify 1%.
Just a database of the people's lives. Right? It's not an interview.
If you want, I'll identify 1%. One person can look at it.
What's the mortgage rate? I've seen that before.
Start talking about this. I say we want to make it an assessment that is reported, or we will address that. And then we just leave.
Okay. 40 times. It's kind of weird. Like it. Yeah.
Yeah.
Sure.
All rise. Fourth and fourth, Station Countdown Center, the Honorable Tony F. Rapp Jr. presides.
Please be seated. Court is now in session. Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good
All
afternoon.
rise.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff
Please be
Hunt
seated.
and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Court is now in session.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer.
Danny Pompa here, owner of Paulding Dodge, Chrysler, Jeep, and Ram with our Christmas specials. The all-new Ram 2026 Bighorn Hemi 4x4 for only $50,700 or 0% for 60 months. The all-new 2026 Ram 2500 Bighorn 4x4 for only $56,900. The all-new 2025 Jeep Grand Cherokee L for only $35,200. The 2026 Jeep Compass Altitude 4x4 for only $29,000. The all-new 25 Jeep Gladiator for only $37,400. And remember, if you're not buying at Paulding, you're paying too much.
Transcript
Also
of
identified
that hearing.
in the briefs.
The second is the state's motion to amend
Mr. Robinson
or clarify the
as well.
publicity
Good
order.
afternoon.
Commonly
For the
known
benefit of the
or
record,
referred to
calling
as the
case
gag order.
251.
And finally,
403,
the motion for limited
576,
intervention, a request for
State of
notice
Utah
to
versus
versus
Tyler James
close,
Robinson.
seal, or reclassify. Counsel, as we're moving forward today, I want to give an
Which has been filed
overview
by
of what
the
we
media
anticipate doing.
organizations and by counsel
And
who are present
it comes
today.
down, we're addressing three
So
issues.
as we
begin, the first
will
is
begin
the
by
October
addressing the
14th,
October
2025
14th
audio recording, the October
of the closed
24th
hearing,
and
transcript.
the October 24th,
This portion of the
2025
hearing will be
transcript
closed.
of that hearing.
So that I may hear from
The
the parties
second is
regarding
the state's
which
motion to
portions
amend or clarify the publicity
recording,
order.
the
The
record
record
should
should
remain
remain
referred
sealed.
to as the gag order.
All members of the
And
public
finally,
and the
the
press,
motion for limited
will be
intervention.
and the hearing will not be broadcast.
To close,
This is
seal,
because
or
I need to
reclassify,
hear what should or should not
and
be
which has been filed
sealed
by
or
the
protected.
media
And it
organizations
would
and
not
counsel
benefit
who
to
are
have
present
everyone
today.
listen to what should or should not be sealed or protected. And it would not benefit to have everyone listen to what should be sealed. And so after I've heard argument, we will invite all parties or the public and the media to come back in, and the hearing will resume transmission. We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today. We will then stand in recess. So at this point, we'll go ahead and excuse the public and the media, and it is the court's order that transmission be terminated temporarily.
Your Honor, we have one request with respect to the closed hearing. May I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother. And we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state.
My only concern with that, Your Honor, is that we're going to be talking about court security measures. And I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
All right. Mr. Novak, do you have authority that supports allowing them to remain in a closed hearing?
No, I think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with Mr. Robinson, and they would certainly abide by any orders the court makes concerning disclosure of what is discussed in closed session. But obviously, it's up to the court.
Thank you, Mr. Novak. I'm going to rule that they will be excluded as well. It is just given the nature and the sensitivity of it, I believe it is appropriate to treat all parties in the public equally, though I do recognize their relationship with Mr. Robinson. Thank you for your request. All right, we will go into the closed session. Thank you.
I can show you guys. I will just pull up because, of course, I've got it over here on the Substack. Just have to find it. What those motions are. Just give me a second here. Here we go. So let me switch over and share that instead. Here we go. This is the motion to amend or clarify the court's pretrial publicity order. And what they're basically doing, they have a pretty good introduction to this motion, but they're just essentially saying, you know, here is what the order specifically provides. Lawyers participating in the investigation or litigation of this case shall inform all witnesses of the prohibitions. And it applies specifically on its face to lawyers participating in the investigation or litigation of the case. So this has been the subject of an awful lot of like confusion and discussion and stuff like that about what exactly this gag order does. Who does it apply to? What are the consequences of violating it? And I want to be crystal clear that the way that the motion is written so far, the way that the order is written so far, it does not directly apply to witnesses. Witnesses are not going to get in trouble if they say anything about the case. The issue is that it's worded in this way that kind of suggests the lawyers might get into trouble if the witnesses say stuff about the case. And so naturally, the lawyers are a little bit concerned about that because they're like, I don't necessarily have control over whether, an eyewitness from the scene or something like that decides that they have something to say. We've seen, for example, Erica Kirk has given a couple interviews at this point. She hasn't, as far as I've seen, given really any detail about the case or any information she's been provided or anything like that, but certainly a risk. Other folks associated with TP USA, have had some things to say. There's been a lot of, questioning about them. They're in a kind of this awkward position where, we don't really want to jeopardize the case, but we kind of also need to defend ourselves against these accusations that are out there. So it's just creating a little bit of muddiness as far as what are the lawyers actually required to do, and what is this gag order actually intended to accomplish? And part of the problem with that is because this was just done ex parte by the court. They didn't have a hearing on this. Nobody filed a motion for it. It just kind of came down. And so the thought process behind why this is necessary, what are the actual risks that we're trying to prevent against, and why does this necessitate what is an extreme remedy in the United States against the First Amendment, shutting people up, requiring them to not be able to speak on issues that they might want to speak about, particularly issues of public interest? We don't know. We don't have the context to be able to understand that. So they had this initial hearing back in September of this year where they asked for clarifications. Who are we even dealing with? If we're required to notify witnesses, does that mean literally everybody? Does that just mean people that we anticipate putting on our witness list? It's not entirely clear, and it doesn't sound like the court necessarily made that. It didn't really resolve that confusion all that well. So they're still required to follow the order and inform witnesses of its prohibitions as the lawyers identify those witnesses. Doesn't really answer the what and the how and what they're required to do and so forth. And so even with the modification, it leaves open the possibility that it's meant to apply to any potential witness, not just those who are members of the teams, who you would be expected to have a lot more control over, right? If you don't want my expert witness out there giving interviews to the press, I can have some control over that because I have a contract with that witness, and I can put an NDA in my contract with that witness. And frankly, if I'm a lawyer, I have probably already done that anyway, because you've got confidentiality considerations with that type of thing.
When you walk into a Burlington, you're walking into low prices and amazing gifts. That's main character energy. Because at Burlington, the deals aren't the only thing bringing joy. Seriously, with these savings, why shop anywhere else this holiday?
Burlington deals brands wow.
So the state's arguing if that's the case, that it's meant to apply broadly, then it is not supported by the law. In other words, the court has not conducted the requisite legal analysis and made the findings necessary for a prior restraint on speech. It is also likely void for vagueness, and to the extent it is meant to apply to witnesses not subpoenaed to testify, it is overbroad. This is because anytime the court is going to shut down content-based speech, it's going to censor you and your ability to speak based on what you might say. It has to meet strict scrutiny. And so what that means is that they have to identify, here's a compelling government interest that justifies us doing it in the first place. In the court context, the criminal case context, they will typically always find it's the right to a fair trial. The right to a fair trial, yes, is extremely important. Right to due process, right to an impartial jury. These are rights of constitutional magnitude, and the integrity of what's happening in a criminal case really depends on those things being honored. So to the extent that people talking has the potential to jeopardize that, it is going to justify some type of restriction on speech. But the issue is, under strict scrutiny, it has to be narrowly tailored. Okay, what you shut people up from, it has to be very specifically focused on what is the harm that we're envisioning? How is this particular speech going to jeopardize that? And how are we making sure that we're not extending this prohibition? We're not making people censor themselves far beyond what is necessary to just achieve this goal of making sure that he gets a fair trial. Because we can imagine, just even in the context of a case like this, there's quite a few different levels of prejudice, that might result from people having something to say. Somebody who was, there at the time, that he turned himself in or spoke to him or the parents or something like that, that person talking about the details of what happened, that has the potential to be significantly more prejudicial than somebody who was just there on UVU campus that day, saw what happened, saw the chaos, doesn't have any personal insight into the investigation and what happened or what didn't happen. And so how can we be sure that, since that second one is really not likely to impact a potential jury pool in any way, that person isn't chilled? They're not worried about, what if this order applies to me? I could be thrown in jail for contempt or something like that. So I'm just going to not speak. That is not allowed under the First Amendment. You have to be very narrowly tailored, and you have to be very clear about what these restrictions are and who they apply to, so that you don't run into this problem of it's overbroad, and so people are not saying things that they have a right to be able to say. The First Amendment is grounded in a fundamental principle that more speech is better, and that 99 times out of 100, the marketplace of ideas is the remedy for bad speech, for people saying things that we don't like, or that we don't want to hear, or that we think might be harmful. There's certainly limits, exceptions to the First Amendment, but they are very specific. Your things like your incitement, your defamation, your true threats, stuff like that. So if it doesn't fall within one of those categories, which generally, talking about your experience, on UVU campus isn't going to do, then you have a right to say it. And in the First Amendment jurisprudence suggests there's a value to you in contributing to the public discourse on issues that are of interest. So essentially, they're saying, look, we're trying to do our best, but if it applies even to potential lay witnesses who are not members of the prosecution or defense teams, then it restricts the free speech rights of citizens without adequate due process, and it's too far-reaching and vague for the state to effectively comply with. And where sanctions for noncompliance by a witness could range from mild, for example, contempt of court, to severe, the state asks the court, wait for a motion. Like, you should have maybe let us argue this. You should have maybe had somebody ask for this, and see what their reasoning is, and develop some actual basis for what are the risks here. What's the jury pool? How many people are even paying attention to the details of this case? comes up a lot with pretrial publicity and concerns about it because, you know, when you're real close to the case and you're following it real closely, it's just kind of natural for people to assume that other people are also paying attention. And there certainly are, but probably nowhere near as many as you think. There's a lot of people who have zero interest whatsoever in criminal cases, no interest at all. You know, might have registered with them that Charlie Kirk got murdered, and that's about it. Like, that's the extent of their interest. Other people might be more interested in it, but are not particularly concerned about the ins and outs of the court case. So they don't follow the details. You know, they just wait for like the big picture headlines that come through, and they have, you know, more or less interest in those, and they retain those, you know, to a greater or lesser extent. So this is the reason why normally you need to have some kind of evidence. You need to have some kind of hearing, some kind of evidence to justify entering a gag order, because you need to know what you're dealing with in order to make sure, you know, number one, yes, there is a legitimate concern here. There's, you know, certainly lots of people are watching this case. Probably a good chance a lot of people in Utah are watching the case. Might be helpful to know like what the opinion is if we've got some type of polling or something like that. If we've got some type of analysis of what the reach is, the intrusion of some of these stories and some of the alleged facts and stuff like that. How widely have they been distributed within this area that is going to be the potential jury pool? A lot of those questions, like we saw in Koberger when they were doing the motion to change venue, have very, you know, similar implications when it comes to things like, do we need a gag order to be able to protect people's rights? We need to know how many people are paying attention to the case in the first place. So the state's arguing it should, if it applies to witnesses at all, it should only apply to prosecution and defense team witnesses. It should not apply to like anybody at all. And this is that reason. You don't have control over them. You know, to make me responsible for what somebody else might say is to put an impossible burden on me. I don't have the ability to make people speak or not speak. Citizens have the right to free speech. Yes, they do. That is absolutely the starting point. So they, you know, are going through a lot of the case law on this. We looked at a lot of this case law in my live stream on the gag order as well. They're arguing it's too vague. If you don't know exactly who it applies to, you have a problem, because anybody that is close to the boundary, they have that incentive to shut up and not say things that they might otherwise have the right to say, because they're going to be concerned, I could get in trouble for this. It's not even clear if it applies to me at all. But I don't want to guess wrong, you know, and find myself in jail. It's a very normal reaction for people to have. But that is not tolerated under the First Amendment. So then he's also arguing it's overbroad, because we don't know what the necessity is. We don't know what the perceived danger is. And so applying it to any and all witnesses is creating the risk that people who have information that's not going to materially prejudice him at all, but it just happens to be, you know, stuff that they know, might be called as witnesses. I got an example for you. Erica Kirk, she's likely to be called as a witness. She's certainly going to be called during the penalty phase, if nothing else, but potentially also during the guilt phase, because it's pretty normal for the state to put on, like, here's what his last day was like. You put it in context. Here's the circumstances that led up to the shooting. Here's his background. Here's who he is. Here's, you know, what he did for a living, so on and so forth. Is that stuff going to be prejudicial to Tyler Robinson if she says that, like, in interviews before trial? It's kind of hard for me to see that. But the way that the order is written, if it applies to witnesses, if lawyers can be responsible for statements like that, then it seems like, they're at risk of being penalized because she's saying things like that. But those seem like the kinds of things that are not supposed to be contemplated under an order like this, because they don't jeopardize his ability to get a fair trial. So that's the gist of the state's motion and what they have argued. Now then we have the defense's response to this. Let me make this a little bigger here. The defense's response, it's quite interesting. So they disagree. We do not agree that there's any problem with the existing gag order. It's fine. Satisfies the First Amendment requirements in the defense's view. So they want the motion to denied. They say totally fine because it's directed at the lawyers. Now, this is deriving from the case of Gentile versus Nevada. This was a case that dealt with the extent to which the court can restrict the speech of the lawyers involved in a case. Every jurisdiction in the country has a rule, an ethical rule dealing with pretrial publicity and the kinds of statements that lawyers are allowed to make or not make. And a lot of reasons for it, but the general idea behind it is they don't want the lawyers litigating the cases in the press. That's what we have a court for. The lawyers are supposed to be officers of the court. They're supposed to be maintaining the decorum of the court. They're supposed to be upholding the integrity of the court proceedings. So they don't want the lawyers out there just giving your whole case to the press instead of presenting it in the courtroom. So there are rules that prevent lawyers from making extrajudicial statements that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. This is almost identical language to the rule that was at issue in Gentile. The U.S. Supreme Court said that rule's fine. That rule's fine. Now, what was interesting in Gentiles in that particular case, they said this guy didn't violate it. And there were a lot of reasons why that was, that gets cited a lot. But a big one has to do with the time. This gets quoted a lot and brought up a lot in these types of evaluations. The time between the statement and the trial. If the trial is like way down the road, according to Gentile, you can't really say it's prejudicial because you don't know how many people are going to remember it. You don't know how sticky that information is going to be. You don't know if these people who are in the jury pool hearing it are, going to move away and not care anymore, not even be in the jury pool, stuff like that. So the time to trial was a significant factor in that case. They also look at there are provisions in most of these rules, and Utah has this type of provision where even though you have this restriction on what is generally speaking intended to encompass showing your evidence, giving your evidence to the press, making your case to the press, there are exceptions for responding to pretrial publicity that you didn't cause. And this comes up a lot, in my view, in criminal cases, because that's what happens 99 times out of 100. You have this massive, information dump, particularly with a high profile case, when you have an arrest and a charge and you have the entire, state's theory is everywhere. And that's what you get to hear. You hear, here's who we got. Here's what we charged him with. Here's the evidence that we had that, or that we say that we had that justified us taking this step. And so, then a gag order comes down and the defense is just, they got to shut it. They never get to counter that. The rules contemplate that they potentially can counter that. So we saw that, for example, in the Richard Allen case. Those of you guys who followed that, the defense attorneys, once they got appointed, they issued a press release, and they responded pretty specifically to some of the allegations that had been made against them. So that got him in some hot water. Court didn't like it. State didn't like it. Heaven forbid that the public get a contrary point of view. The public might get the idea that like there's an actual defense here, right? Can't have that. But what they did is completely legitimate under most of these ethical rules and under the reasoning of Nevada versus Gentile. And at the end of the day, they dealt with a lot of hassle with that in that case in terms of the court, but they never got in any kind of like ethical problems with it because there weren't any ethical problems with what they did. So the defense again is just saying, this tracks the existing, tracks the existing ethical rules that the lawyers are already subject to, imposes a duty on both counsel for them to take reasonable care to prevent others associated with their respective teams. It does not purport to specifically order non-attorneys to limit their speech. Okay, so even the defense is agreeing this order does not apply to witnesses. As it's written, it only applies to the lawyers because only the lawyers are subject to the rules of professional conduct that this order is encompassing. Non-lawyers don't have to follow the lawyer's ethical rules. And so according to them, it's totally fine because it's only the lawyers who are potentially jeopardized by this order. And it's fine because all the order is telling them to do is to follow the ethical rules that they would already be subject to. I don't particularly agree with that characterization of what the order is doing. But that's generally the argument that they're making. So they're just saying, counsel is on notice that you have a duty to not do things that could jeopardize his right to a fair trial, which of course is completely legitimate. The question is, does the order clearly, unambiguously, not overbroad, actually do that? Now, here is where we have the interesting footnote to the defense's argument here. Just going to read it out. Mr. Robinson also intends to file a motion to modify the order, but will do so separately from this response to the state's motion to amend. As his motion will explain, it is Mr. Robinson's view that the order should go further to limit the public. That may be made by persons associated with the prosecution, including potential lay witnesses, and that could be enforced if necessary through contempt proceedings directed at those persons. Wow, the defense potentially wants to throw witnesses in jail for speaking. That's kind of wild, honestly, kind of wild.
True crime just got darker. Catch the full episode on the link above. Subscribe to At Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.